Hello everyone, welcome to our channel. My name is Damilola Adesanya Esquire. So today I have an interesting topic to discuss with you, which is how to resolve family conflicts and inheritance disagreements. If you are new on our YouTube channel, kindly click on the subscribe button. When an individual with children dies intestate, that is, without a will, the next line in action is the distribution of the deceased estate. Then there will be an argument as to who inherits the deceased property, or should the estate be allocated in accordance with the customary law or English law. So if they are unable to reach a conclusion, they can now decide to institute an action in court in order to know who is entitled to inherit the property and whether the property should be distributed in accordance to the native law or the English law. So before I proceed into the main topic for today, I would like to explain to you on the customary law of inheritance for the three most recognized tribes we have in Nigeria. So we have the Yoruba tribe, we have the Hausa, we have the Igbo. So under the customary law, the Yoruba customary law of inheritance and succession, only the deceased children, that is both male and female, can inherit. However, the eldest male child, which is called the Daudu, is automatically in control and management of the deceased father's estate. There are actually two methods of distribution under the Yoruba customary law. We have the Idigi and we have the Ori-Ojori. So the Idigi means per stripes, the Ori-Ojori means per capita. So under the Ori-Ojori method of distribution, property are distributed among the children directly and equally, regardless of who is older or younger. So this method of distribution is usually used in a monogamous family or in a polygamous family where the deceased has enough property to go around among the children of all his wives. So now this method is no longer in use. It is no longer in use in most families again because it brings injustice. For instance, when the first wife started from the scratch with the deceased, maybe the first wife actually built the estate with him, and then she had a child or two, and the other wives had 5 children, 6. So this method will actually be unfair on the part of the first wife to inherit less than the other wife based on the numbers of children they have. So now we have Idigi, which is the second method of distribution under the Yoruba customary law. So just like I said earlier, the Idigi means per stripe. So in a situation where the deceased has more than one wife, the Idigi method is usually used as each wife representing Igi, meaning branch. We have the Igbo customary law. The female child is actually excluded from inheriting the property of the father or even their husband. So the tradition says that the first son inherits. He may actually share with the male siblings, but not with the female. So by tradition, widows do not have rights. They do not have rights and can even be regarded as the property of the deceased husband's male relatives. We have the Benin Kingdom. In the Benin Kingdom, the entire estate of the deceased belongs exclusively to the eldest son, who act like a trustee for the other children. That's for the Benin Kingdom. So now we have the northern Nigeria. In the northern Nigeria, they operate Sharia law. So under the Sharia law, a daughter can inherit from her father's estate. The widow to the deceased has the right to 1/4 of the estate of the deceased, who is without beneficiary. So if there is more than one widow, 1/8 portion of the deceased property is shared between them. In general, women can inherit property. Likewise, they can pass it on to their heirs, inherit it from their deceased parents, husband, brothers, sisters, daughters, and other relations. So to avoid disagreements caused by customary way of distributing the deceased property, the best thing is for a person to write a will. However, note that a will can be contested if it does not include the true wishes of the testator. What do I mean by this? The validity of a will can be challenged based on its defective form or its substance. So in the next video, I'm going to explain to you what it means to say if a will is actually valid. So just like I said earlier, I said a will can be contested if it has a defective form or substance, or if it has not been correctly executed and is found with elements of fraud and forgery. So the best way to minimize the risks of disputes and legal problems over inheritance is by involving a lawyer. So to resolve disputes for families whose loved ones die without writing a will is by applying for letters of administration at the probate registry through their lawyer. I hope you've learned one thing or the other from my video. Don't forget to click on the subscribe button below and also like and share our videos. Till we see you next time, my name is Damilola Adesoya.